Hello, everyone. Thank you for joining us. We will get started in just a moment. Okay. Hello, everyone. Welcome or welcome back. This session is in recent exposure, current topics in trademark law. I want you all to know that that pun was not mine, by the way. That pun was Anne's, which I think is really impressive. Anyway, this session has been sponsored by Vodra International. Make sure to check them out. My name is Bree Van Til. I am the Director of Education here at Alt Legal and your Master of Ceremonies for Alt Legal Connect. I'm here to make your experience amazing, so please let me know how I can do that. If you have any feedback for us, please put that in the feedback form on the right of the page, just so that we can know what's going on and what we can do to better serve you. I do want to remind you about our code of conduct, again, in case you've forgotten in the past 2 hours. Just don't be a jerk, please. All right. So we will be offering CLE credit for this session through the state of California. Please note that you are required to attend this live, so we're not able to give you credit if you're watching this via recording. You're still going to learn a ton. I would definitely recommend still watching this, but we can't provide you credit or help you get credit in your state. You also, in order to qualify, you need to be here for the entire 70, that is 70-minute presentation. When I say the code, make sure to write that down. I also have pen and paper or something. Please don't try to memorize it. It does need to be exact and it will not have any spaces in it. We will send a survey at the end of the session where you'll put that code. So please put it in there. All right, again, we're still a legal technology company, not a law firm. So no legal advice is coming from us. And while this panel is great and lovely and wonderful and they have great views, they're not necessarily those of Alt Legal, just so you know. So like before, I'd like you to use the chat to talk amongst yourselves. But if you have any questions for the panel, make sure to put those in the chat and use the word question in front of that. And somebody from my team will get those questions over to the panel. So I am pleased to welcome our speakers. First, we have Anne Gilson Lalonde, who is the author of Gilson on Trademarks, a multi-volume treatise that has been in the works for decades. Anne recently served on the USPTO's Trademark Public Advisory Committee, and she has penned a mighty impressive number of articles and other works. Rebecca Gahn is a former USPTO trademark examiner and a partner at Windroth Linden Ponak. In addition to trademark prosecution, Rebecca also litigates trademark oppositions and manages TTAB oppositions. Additionally, I'm pretty sure she speaks all the languages. Irene Lee is a partner at Russ, August, and Cabot. Irene has been practicing trademark and patent law for over 20 years. I kind of want to know what moisturizer she uses because that doesn't even seem possible to me. But Irene is a litigator and has tons of accolades from her decades of practice. Here is our panel. Take it away.
Can I just mention the Honest Company?
Please do. Thanks for sharing. We appreciate that.
Thank you, Bree. And Bree is amazing. I just have to say, she is tireless. She's just incredible. And so we have a lot to cover today, including the Trademark Modernization Act and a pending bill on counterfeiting and online marketplaces. We're going to talk about dog toys and puns and satanic footwear. So stay tuned. First, I'm going to give an abbreviated overview of the two new proceedings from the Trademark Modernization Act, expungement and reexamination. And then we're going to talk about them from the petitioner's point of view and the registrant's point of view. The purpose of both of these procedures is to get rid of marks that are not in use or weren't in use at the appropriate time. So to cancel those registrations quickly and hopefully efficiently. Um, the TMA left a lot of details to be worked out, and the PTO published a notice of proposed rulemaking in May. The PTO is presenting on Wednesday in this conference at 11 o'clock, so be sure to tune in for that. There'll be a lot more detail than we have time for, but the PTO does have to start accepting petitions on December 27th of this year. An expungement petition claims that the trademark and the registration has never been used in commerce. You'll be able to file an expungement petition against any registration, no matter what the basis is, but the owner of Section 44E or 66 registration can show excusable non-use and avoid cancellation if they're able to make that showing. All right, I'm gonna put these in if you stop the feedback, hopefully. So any registration that is older than 3 years can be challenged until December 27, 2023, and then there'll only be a challenge allowed between 3 and 10 years post-registration. So there's the window closes at the end of 2023. Re-exam is similar but different. The claim here is that the trademark and the registration was not in use in commerce when a use-based applicant filed the application or during the time for filing a statement of use if it's an ITU application. So this is targeting registrations that had bad specimens. They're either fraudulent or just inaccurately claimed use. You can't file a re-exam petition against a Section 44E or 66 registration. They didn't have to show use at the time of the application, so it wouldn't make sense. But other registrations can be challenged anytime up until they're 5 years old. There is no standing or damage requirement. Anybody can file a petition, but the U.S. Council rule does apply, so foreign domiciled petitioners are going to need a U.S. attorney. On the petition side, all petitions, even if no proceeding is instituted, they're going to be public and viewable in TSDR. The proposed fee right now is $600. We'll see if that changes. And petitioners are going to need to conduct a reasonable investigation and present facts and evidence to the PTO. If you make a prima facie case, the PTO has to initiate a proceeding, and the petitioner's part is completely done once you file the petition. You have no role in the rest of the proceeding. If the petition fails, you can still bring a cancellation action at the TTAB. Under the statute, it can't be held against you if you filed a petition that didn't succeed. On the registrant side, the PTO is proposing a 2-month response deadline, and you have to respond and present documentary evidence of use. The rulemaking does suggest that they're going to notify registrants when a petition is filed, so you might be able to start preparing the response earlier if you're willing to, if your client's willing to put in the money before the PTO decides whether to institute a proceeding. And then if the examining attorney decides there wasn't use, then the unused goods and services are going to be deleted from the registration. And you can ask the examiner for a reconsideration or appeal to the board. And one more note here, non-use never having been used, it's now a ground for cancellation at the board after the registration is 3 years old. So it seems like this should already have been a ground for cancellation. Oh, the mark's never been used. Can't you cancel it on that basis? Well, yes, but the board has always treated it as an abandonment claim. So let's talk about the nuts and bolts of this, of whether these are good ideas or not. And so Irene, do you want to tell us from the petitioner's point of view? Could these be useful?
Yeah, so thank you for walking us through. This is always good to be reminded. So I think it was a couple of years ago or so, the Supreme Court came down and struck down the ban on immoral and scandalous marks. And there were like all these rumors and folks talking about, oh, there'll be a flood of filing for applications on including profanities. We didn't really see that. And then there are other mechanisms to deal with some of those kind of common phrases. So I don't really see a lot of folks out there looking to launch all of a sudden reexamination or expungement or non-use based cancellation campaign. What I am seeing amongst the practitioners and personally myself is I think this is a kind of a streamlined methods and tools for petitioners to remove some of those dead weights. And usually I think of this as the ways that we usually use when we're filing applications outside the United States. And we file an application outside state and we get cited, usually in China. You file an application, there are 6 different registrations cited against your application. And because most countries do not require you to use the mark in order to obtain a registration, oftentimes there are ways for us to establish non-use based cancellations to kind of remove these obstacles along the way. So I think these are additional tools that I could see the petitioners utilizing to remove those obstacles. Yeah, I don't really see folks like gearing up to file a bunch of those proceedings. Um, I think that when we are thinking of oppositions and cancellations, it's a kind of a streamlined, limited litigation proceeding. Even though this is before the board, it can get very costly through discovery. So I think this is a way to address this costly and time-consuming cancellation proceedings. So I, with caution and reservation, welcome this. I do have some reservations, and I share some of the views that Rebecca will share. But for now, I think this is something that I would definitely consider utilizing, with one caveat. We had some incidents where we knew for fact that the cited registration against our client's application were not in use. We did our investigation. We hired some professional private investigators to do that. And the way we worked this out was we agreed to expedite the cancellation proceeding. As part of the 26F, like a discovery conference, we invited the interlocutory attorney so that the discovery conference really focused on the registrant. Did you use your mark? Can you prove it? So I think there are ways to get there without having to have these tools, but I still welcome, and I'm curious as to how this is going to play out.
Yeah.
I don't welcome these tools. I'd like to point out that first exam has now ballooned to over 6 months. I have not seen a gear up in staffing. I don't know how they're possibly going to do this in a timely way. Expungement proceedings in Canada take a really long time. So I'm not super confident that this is going to be a timely thing. And also, we already have these tools. I mean, yes, non-use has not been a separate ground for cancellation, but people have been filing. I file these all the time. You have several paragraphs saying they haven't used it, and thus they have abandoned it. And the board works through those petitions pretty quickly. And, if the other side doesn't respond, it's pretty cost efficient. I'm not clear also, Anne, if the PTO still takes the position that representation of a registrant ends at registration, who are they notifying? Because any Italian client, I would just petition them in the summer and they'd never respond.
Right.
So I think you're going to have a lot of people coming back and saying, oh, I never got this. We're in a pandemic, PTO. Have you not heard?
Right.
So I think that's a problem. I also think that, excusable non-use, if they're using the same standard that they use on maintenance filings, again, if I'm an Italian company, I might just say, well, we filed for bankruptcy. If I'm a drug company, I would say, well, we don't have FDA approval. I mean, there's a whole list that they generally accept, and they spell those out in the TMAP, but they sometimes take lots of different things. Obviously, we're in a pandemic, so that would be a reason to not be able to export something or attend a trade show. So, I mean, I'm not very happy with our post-registration audit system. I don't think it works very well. I think the PTO treats every registrant as if they make a t-shirt or a hat. And if they can't produce the t-shirt or the hat, it's like they're not using it. But if you make very high-tech goods and you make replacement parts for these machines, you can't often come up with a specimen for them. You can give them 30 invoices with the mark on them, and the PTO will say, oh, it's an invoice. No, I won't look at that. But because you can't get this tiny little sensor to have the mark on it, it's not in use. I mean, that's sort of the position the PTO is taking, and I think that is a false narrative that they are projecting. Also, 2 months is very quick,
right?
Considering that the PTO is taking over 6 months now.
Right. I think they are trying in the notice of proposed rulemaking. They suggested some kind of procedure that if you didn't get notified, if you really didn't know that this proceeding was instituted, that you could reopen the proceeding. I don't know. So we'll see what happens.
You can reopen the proceeding. And what happens in the meantime when people are searching? Is your mark?
Maybe we'll see how quickly they are to delete the goods. And I don't know. Yeah, we'll see what. Yeah, come and ask that question on the at the PTO panel. All right, so we're going to move on. I just want to note briefly another provision in the TMA that I think a lot of people are not aware of, the irreparable harm presumption. For years, federal courts had held if they find trademark infringement or likelihood of success on the merits, they're going to presume that there was irreparable harm. And then the Supreme Court just broke this presumption. I think circuits were following this incorrectly, but be that as it may, now it's back. The TMA has added language to the Lanham Act that confirms the rebuttable presumption of irreparable harm. And it's there for both preliminary relief and for permanent relief. And also I'll note that the TMA says that it's as if the presumption never left, that plaintiffs were always entitled to this presumption and they're entitled to it now. This language didn't make it into the Lanham Act, but if you need it, it's in the Trademark Modernization Act itself as a rule of construction. I will note too that courts do not, also defendants can still rebut the presumption. Also, it applies to all Lanham Act violations, which may be different from previous. And courts are completely unaware of this. There are just a few cases so far that realize that the TMA has changed the law. Some of them are still citing boilerplate from the 80s on this. So you're going to have to spread the word and educate the judges. So, Rebecca, would you like to tell us about dog toys?
Dog toys 2.0, dog toys during the pandemic. So we have a very interesting Ninth Circuit case that deals with dog toys and the First Amendment, and brings back a case from many of our youth involving First Amendment claims in the title of a movie, which I believe was Ginger and Fred, which was a Fellini movie. So let me just advance the slide here. So we had Jack Daniels, by the way, makes dog toys. And that's why this case is a little bit different than the Chewy Vuitton case that you might remember from a few years ago, which was decided actually not on First Amendment grounds, but on likelihood of confusion grounds. And in that particular case, which is footnoted, I believe, in this VIP Products Jack Daniels case, the court had said essentially, well, we're finding on likelihood of confusion because Louis Vuitton doesn't make dog toys, so we don't have to get to I think, the First Amendment issue here. But in the Jack Daniels case, essentially, the Ninth Circuit held that the district court had erred because they had not considered the dog toy to be and I think they used the language artistic work, not expressive work, but expressive work is the First Amendment language, and it's the language we see in some of the cases that they cited. So they said that the district court erred by not looking at what the dog toy as an artistic work or as an expressive work, because it was funny. So now funny is the test for whether or not something is artistic, which I think collapses any type of commercial speech down to being essentially shielded from infringement here. So in these particular cases that deal with dog toys, I think we had talked about this earlier, that there's kind of an import of terminology that we see a lot in copyright cases, which makes a lot of sense because copyright cases tend to be longer and tend to be more artistic works, and they tend to deal with things like songs. And so, of course, when you hear a song and you look at a song, you say, oh, yes, what he's doing here, Two Live Crew, is parodying Roy Orbison, but he's also making a commentary about misogyny or womanhood or whatever, but he's commenting on something that is occurring in society. So in the dog toys case, essentially, it was remanded because they did not consider this other case, which is the Rogers case, which I think is from 1989, which, as I said, dealt with whether or not the the movie title, Ginger and Fred, was shielded from infringement because the title itself was artistically relevant to the movie. It was a Fellini film that dealt with Italian set of impersonators of Fred Astaire and Ginger Rogers, and in the twilight of their lives. And so the Rogers court had held that the title was artistically relevant to the actual work itself, because that was kind of the motif in the movie, and whether or not the work was held, or that whether or not the use of the mark was held to mislead the consumer. In that case, it was a moviegoer. Would they really think, because the plaintiff in that case was an aging Ginger Rogers, would they really think that the movie was somehow authorized by her or emanating from her? Now, because, as we said, Jack Daniels actually makes dog toys, the the appellate court had said, well, okay, so they are actually competitors in the space, but we think that the district court did not properly consider the Rogers test, because this dog toy is really, even though it's commercial, it's expressing something. It's humorous, and so they need to be able to do that and not be sued for infringement. So it was remanded back to consider the Rogers case. And so we put up here some of the other cases where they talk about this particular issue of whether or not essentially a commercial product can be an expressive or an artistic work, which is not intuitive, I think, to practitioners, right? I mean, you can understand why a song, another case from the Ninth Circuit, which is a copyright case that many of you remember the song, I think it was a Danish group, the Barbie doll, and Mattel sued them, and the Danish rock group said, hey, well, what we're doing is we're taking on the patriarchy in the song. We're using the Barbie paraphernalia to make a point about the status of women in society. And they were successful because, again, it's a song. So they're saying something. They had an intended video here. It's not very intuitive to take something that's a commercial product. And here the court said, well, it's not purely commercial. And I'm like, it's a dog toy. So I'm really not sure how it's not purely commercial. Like a song, I could say, yes, that's not purely commercial. It's making a lot of song, but it's a commentary. But it's a dog toy. And I think it kind of collapses this whole kind of debate. And is, besides not being super intuitive, it kind of, I think, flies in the face of some other cases that we're seeing in other districts. So district courts. So I think another issue that we talked about in connection with this is, why does aesthetic functionality keep coming back? Because we've had all these cases, including the Supreme Court, saying, hey, stop doing this. Because, again, this really would collapse everything we do, so that there is no trademark infringement. And aesthetic functionality, as you recall, is basically like when courts, it's a court test, look at products and say, well, is this something the competitor would need, this beautifying element of the product? Is there a competitive need on the part of someone else to use it? Is it, super catchy? And if the stickiness of it is somehow aesthetically pleasing, well, then, we really shouldn't be giving them the right to stop competition, essentially, in the marketplace. And so, again, if we're looking at some of the cases that we've looked at have dealt with colors, and courts have said, well, it's not necessary for a vacuum cleaner company to have a red vacuum. So, and that doesn't seem to be serving any particular functional purpose, like pure utilitarian functionality, but it's not really serving an aesthetic purpose either. It's pleasing, but there's no real need there to have that. So we'll give you the right to enforce against others to preserve the color of the vacuum cleaner, but we won't do that in other cases where we think that others need a right to use it, or we think that it's, particularly sticky. Because again, the origin of trademark law is supposed to be protecting consumers, and we as a country believe in competition. So just because it's beautiful doesn't mean you should get a monopoly on it. And I think that courts have rejected that because, as I think McCarthy has pointed out, if you put a court in a position of determining whether or not something is aesthetically pleasing or artistic enough, the result is seldom satisfying for anybody, right? But one case which I think is interesting about aesthetic functionality, and again, this is from the Ninth Circuit, has to do with the pun, right? Let us turn up the beat, because again, I think this actually makes a little bit more sense. We want the public comments to be robust. We want people to have to really develop secondary meaning if they're going to fleece the public domain and take wording, including puns, out of the public, the right of the public to use it. And so here we have a case dealing with let us turn up the beat, and the court held that the pun was aesthetically functional, and therefore they couldn't succeed on infringement. So, I mean, there again, I think that kind of makes sense. But we have some more Ninth Circuit case law here on aesthetic functionality, which suggests that it's just not dead as a doctrine, and it doesn't matter how many times courts, including the Supreme Court, have tried to kill it. It just keeps coming back. And again, I think that's the tension in trademark law between promoting competition and protecting the consumer. But as we've talked a little bit amongst ourselves, you have clients that really have invested a lot of time and money and energy in developing a cool product, and we all benefit from beautiful design, especially in the workplace. We all benefit from design, and so there has to be a way to reward some of that innovation here. And so again, we're going back to Louis Vuitton and how they dealt with aesthetic functionality claims against their logo design, and they just put together lots and lots of consumer declarations. And so I think, again, aesthetic functionality, it lives and breathes. I don't think that, well, it's interesting. We would talked about the Jack Daniels case, and just to point out that the Supreme Court did not pick it up. So we don't have a final answer on it, but it does seem that whenever things are politically dicey in the political realm, they pick up IP cases, and then they reap havoc and they go on in their merry way. So I think this issue is going to come up again.
So speaking of, I want to pick up on that and go back a little bit to the dog toys. I think these are all really interesting to talk about together, though, because there is the same tension. But the Supreme Court in Ray Tam said trademarks are often expressive, and I don't know if I would say expressive in the sense that they're always, they're expressing political views or opinions, but I'm concerned about, for the expressive use test, for the Rogers test, are courts going to take the Supreme Court at its word, as they did with eBay v. Merck Exchange, and mess up the preliminary injunction standard? Are they going to say, well, okay, well, words are expressive, but you can imagine, say, Simon Tam, who owns the Slants, say that that trademark was infringed on another mark, and would he be able to say my trademark is expressive, and so the standard should be explicit misleadingness and not likelihood of confusion? So yeah, I'm concerned about the kind of the bleed into word marks. Irene, did you have a thought about
Yeah,
that?
so it seems to me that once the court says, or if the argument is established that there's expressive content, it just kind of takes you to the Rogers test. And then because the first prong, the artistic relevance, is such a low standard to meet, I think as soon as you say this is expressive work, it's really hard for the plaintiff to argue that it is not artistically relevant. So if I were a plaintiff asserting my rights, I think I have to go to the second prong, the explicitly misleading. And when you were discussing this, I was thinking of I think the Jack Daniels case does make a reference to the honey badger don't care. And even in that Ninth Circuit case, there is a kind of a dicta coming from the Ninth Circuit in the honey badger case, literally says, in some instances, the use of a mark alone may explicitly mislead consumers about a product source if consumers would ordinarily identify the source by the mark itself. So even in a case where the accused infringer did nothing else other than using a trademark, there are cases where the court will still say, oh, yeah, we got the Rogers test done. I think that's something that we may see more and more. So I think that's, even though it has two prongs, to me, once you get into this Rogers test arena, artistic relevance is not, it's just a paragraph, and then you just check mark and you move on to the next prong.
And I think courts have said it has to be over 0 if the artistic relevant, because they
Thank
don't
you.
want to be in the position of saying, well, is it relevant to the work? Is it not? So these are both incredibly low bars, or high bars, I guess, for explicitly misleading. These almost never are met. It's always artistically relevant. It's never explicitly misleading, except for a very few exceptions.
Well, but the thing is if they're already making dog toys, I don't see how you could say that it's not misleading, because they're in that, they're not expanding the realm. They're in the realm, right? So I find that really difficult. If someone is already in a space, or they're a company, again, this is going to benefit bigger companies where they're like, well, we've got licensing deals, people. We're going to do this. So obviously you're trying to mislead our consumers. I mean, I don't know. I think it's very, very dangerous. And again, I think it feels comfortable to First Amendment people, and I consider myself a First Amendment person, especially to have a very robust defense to copyright infringement. But this is something very, very different. And they need to start calling this commercial speech and explaining to us why this is different. Even though the Supreme Court has said, well, it can be commercial and it can still be expressive. And look, they're reclaiming the language with the slants. Right. But what are they reclaiming here? I mean, that's a very specific applicant who's saying, look, I am making a statement about Asian identity in America with this mark. These dog toy people are making money. Let's be real. What are it's funny. If funny is the test, what's the point?
And is let us turn up the beat expressive because it's arguably
because it's cute.
Funny.
If cute is the test, again, and I think just going back a little bit on the pun point, that is actually something that the PTO is doing that I'm kind of in favor of, unless I'm defending it, which is they are kind of saying, hey, stop fleecing the public commons here and trying to register these common expressions, because it's a problem and you're wasting government resources and you're going to get a piece of paper with a gold seal that's unenforceable. Why are you doing this? And that I buy. And that I think is kind of an extension of what the Ninth Circuit is doing and let us turn up the beat, which is to say, look, this is a bridge too far. This is not, we're not going to give you a cudgel to go after people because you're taking a cute pun that you probably are not the first person to come up with and you're trying to sue people. We're not going to do that.
And another point that concerns me about the aesthetic functionality are the cases that suggest that if consumers like a logo or a brand, then it should be available to everybody. I mean, that's not where the aesthetic functionality kind of came from. There's sort of an appealing like color like gold and green for Christmas products. You can't monopolize that. But then when you say, well, can you use these other marks just because people want t-shirts with the Chanel logo on it, therefore it's aesthetically functional, it's available. So yeah. All right. So do you think this was rightly decided? Do you think this should have been a failure to function, or is that?
I think that ultimately the decision is right, but I still have a hard time following the logic. I think if the plaintiff had a better, maybe did a consumer survey instead of just putting just one declaration from the owner of the mark, because the owner of the company initially owned the mark, and then I guess he assigned it to his company. That was pretty much the bulk of their argument. I think if they did a better job explaining the recognition of the brand amongst the consumers, I think this might have gone a little differently, or at least there would have been another wrinkle. I recognize that the Ninth Circuit didn't want to just invalidate. I mean, it is an incontestable registration. So they don't say it's completely invalid, but it's just a drop in a footnote saying, I'm not saying it's invalid per se. So I found that very interesting how the Ninth Circuit is kind of walking this line very carefully.
The unpredictable Ninth Circuit, as we all know. So just briefly, I know it's maybe a little strange to talk about pending legislation, but I think a lot of people were surprised by the passage of the Trademark Modernization Act in the lame duck session. So we thought we would give you just a little preview of a pending bill that may be on track to become law, so that you'll know the basics if it's enacted. It's the Shop Safe Act, which is one of these terrible congressional acronyms, stopping harmful offers on platforms by screening against fakes in e-commerce. That would be a pretty great job to come up with the acronyms for legislation. So this was introduced in the House and the Senate in May, and there have been several virtual roundtables with stakeholders. Obviously, there's no guarantee this is going to be enacted, but it seems like there's a lot of work going into it. It has bipartisan support in the House and the Senate. So we just wanted to describe it to you. What the bill is trying to do is make a dent in the enormous number of counterfeit goods being sold on online platforms like eBay and Craigslist and Amazon. So it involves contributory liability for e-commerce platforms for counterfeits sold by third parties. Right now, the standard generally follows a Supreme Court case from 1982, Inwood Labs, that was echoed in an e-commerce platform case about a decade ago. And a platform can be found contributorily liable if, one, it intentionally induces a third party to sell counterfeits, or two, it continues to supply its services to a third party it had reason to know is selling counterfeits on the site. So the Shop Safe Act, it would amend the Lanham Act to almost flip this standard and essentially presume liability for the platforms. So they would be liable to owners of federal trademark registrations. Those are the plaintiffs. You can't you wouldn't be able to bring an action for a common law. If a third party sells a counterfeit product that implicates consumer health or safety, and 2, the platform failed to follow every single best practice listed in the statute. In other words, the platform has to follow all the requirements, or it can be found contributorily liable for the sale of this counterfeit good. There's a wide range of these best practices. So this is just a kind of a broad listing of what's in the bill. Third-party sellers have to have agents or verified addresses for service of process. The platform has to verify the seller's contact information and provide it to trademark owners if there's a reasonable basis to suspect counterfeiting. The seller has to display its contact information and the country that the goods are being shipped from. This has to be on the listing on the site. The seller has to also promise it won't use a counterfeit mark, which is very sweet, and also has to promise it's taken steps to vet its products and authenticate them, and promise that it's, I'll get you, Bree, in 1 second, and also, the platform, interestingly, has to implement reasonable, proactive technological measures that screens for and removes counterfeits before they're even displayed to the public. So that's the long list. So before we start talking about it, over to you, Bree.
Okay, I'll be really fast because I don't want to interrupt the Shop Safe Act. It's time for the CLE code. So get your paper to write this down. The code is 6 update 2. That is the number 6, the word update, which is what you will be after. You will be updated after this talk. And the number 2, again, all one word, no spaces. 6 update 2. All right. Sorry, please continue talking about Shop Safe.
Thank you. So I just like to ask the two of you if you think the system is going okay now as it is, and if you think this is a good way to fix what might be wrong. I mean, one of the ideas I think with Shop Safe is right now the burden is really on the trademark owner to try to try and find the counterfeits and take them down. I mean, the platform certainly act, but does it make sense to switch the burden entirely to the platforms? So, Irene.
So whenever we see the counterfeit products, whether you're representing the platform or whether you're representing the trademark owner, I think one thing that just placing that burden on the platform, as much as I would appreciate that from the trademark owner's perspective, I don't know how feasible that is going to be, especially if you are requiring them to kind of screen things even before there's a request for a takedown. So realistically, I just don't know how that would be feasible. From the trademark owner's point of view, we do have a number of clients who've been using Trademark continuously for years. I actually got a call from someone, they've been doing it for 35 years continuously, but they don't have a registration. So this is one of those discussions that I have to have some of the trademark owners out there. Get a registration. It's not, 2015 anymore. Like everybody's doing online now. So especially if you're going to have any presence on like a Walmart marketplace, Amazon, nowadays, in order to even participate in Amazon registry program, you have to have a registration. So I think this is a discussion that I'm having more and more with clients. And you do not have to have attorneys to do those registrations, even though it would make our life so much easier. But I think there is a value in getting a registration, and it wasn't the case before. I think in other countries where they don't require use in, to get a registration, yes, the registration is more important. In the US, as long as you use your mark, you have your trademark. Nowadays, even though that is the law, when you're in this business world, I don't know how people can enforce effectively, especially if you're talking about takedowns, because I don't usually recommend clients, filing lawsuits just to have a takedown just because you don't have a registration. So I think more and more, I think we see the importance of getting a registration.
I would agree with that. And the clients that are usually problematic, that's when it's a family company and it's their family name. And they're like, well, we've been around since 1982, Rebecca. Why do we need this? Well, you want to sell that finished leather product on Amazon, and you're not going to be able to do it because you don't have a registration. You're not going to be able to stop people from selling counterfeit leather goods because you don't have this registration. I don't know who your typical client is that doesn't have a registration, but for me, it's always the most difficult when it's like a family business that has been around for a long time because they feel like they're well known, they don't need it.
Same here. And then the one thing I noticed recently is it's a US company. They've been operating for over 5 years under that brand, but they got big. So they were pretty well known outside the US. So, folks outside the US register in the US. So they're the ones who are going to Amazon showing US PTO issued registration for the mark that our clients started using in the US first. But our clients, the whole site got taken down because they didn't have a registration. It was right before Thanksgiving. So sometimes you see these things happening. It's really hard for me not to emphasize the importance of the registration.
So can we move on to the satanic footwear?
Of course. So let's see. So this got a little more publicity than it deserved. I think it's because it's Nike, it's Little Nas, and you can see a little bit here, Nike swoosh logo is prominently displayed. I think it's not disputed that this is a famous trademark. Nike as well as a swoosh. And when you look at this particular item that's with the red background, you can't really see this, but there is a 6 out of 666 that's in red. And that indicates that the mischief, that's the defendant in this case, manufactures 666 pairs of this particular Satan shoes. And they announced this product on Twitter and other social media very prominently on Friday, March 26th. March 29th, that's when the complaint was filed. So Nike didn't skip a beat, because what happened was over the weekend, you can only imagine the people chiming in and talking about how they're not never going to purchase Nike. I can't believe you're doing this. There is a boycott happening against Nike. So one thing that we are looking at here is in the context of this case, I do want to just touch upon the fair use doctrine just a little bit. And then we can touch upon the first sale doctrine and then the First Amendment as well, because those were all raised. But here, I think we all have an idea as to what fair use is. I think the ones that we often see is classic fair use. And this is about you're describing the functionality, the nature, the result of your products or services, or geographical description. So we see a number of examples that we've seen before where you're just purely describing, and there's just no other way to describe it. I think here, the fair use, what we are discussing is nominative, and because they're using Nike. But usually the proper nominative fair use is, Pampers talking about Huggies. So the comparative advertising, we used to see those, Diet Coke commercial I think it was like a Pepsi truck driver drinking Diet Coke. So those are nominated fair use. And also when you're driving by some, car repair shops, you see we repair Bentley, we repair Volkswagen, or we brew Starbucks. Those are all nominated fair use. What I found interesting though in the Jack Daniel case, the VIP products, the dog toy company did raise this argument, but they said they didn't use Jack Daniel's trademark. So their nominated fair use argument was actually rejected. So you actually have to use the other side's trademark correctly, in the identical way. So here, the nominated fair use, there is I wouldn't say like split per se, but we usually think of nominative fair use as not an affirmative defense, but more as a kind of modified likelihood of confusion test, because it came from the Ninth Circuit and the Ninth Circuit says so, but the Third Circuit actually used this as an affirmative defense. So that's one thing that you might want to think about when you have this defense. So 3 elements that you have to look at. The product or service must be one not readily identifiable without the use of the mark at issue. So right now we're talking about the shoes, and the shoes, in fact, was properly purchased by Mischief, and this particular model was Nike Air Max 97. So that was their use. Number 2, only so much of the mark may be used as reasonably necessary to identify the product or service. And here again, they didn't really go out and say, Nike endorsed it or sponsored it. They didn't really do anything more. So that's the second prong there. The last one is user must do nothing that will suggest sponsorship or endorsement by the mark holder. So again, it's kind of tied to number 2. And it also takes me to a little bit of the Rogers test we talked about, whether they went a little overboard and explicitly misled the consumer in any way. But anyway, so these are the 3 elements under the nominative fair use. Okay, so this is what they did. Nike Air Max 97 shoes. They did put red ink under this air bubble in the insole, and then they claim that they dropped like 1 drop of human blood, and then there is a lot of satanic theme detailing going on there. There is a Bible verse from the book of Luke 10:18 talking about the like a Satan falling, and then they did talk about inside the sole as well, and outside there are some other decorations. And of course, manufacturing 666 pairs of shoes. So that's the extent of their advertisement. What happened though was instantly Nike got a lot of publicity, and not all publicity is good publicity here, because they did get a lot of boycott. I can't believe you did this. So they Nike, when they're putting together their complaint, they dedicated 1, 2, 3 pages to screenshot it. This is terrible. Won't buy Nike again. You're banned. It goes on and on. So I think that was pretty compelling evidence of likelihood of confusion. So if you are doing the nominative fair use analysis as part of likelihood of confusion analysis, and then if you already have this overwhelming amount of purported evidence of people actually confused, and these are folks, some of them are arguably like sophisticated sneaker collectors who will actually pay extra to buy these collector's items. Hold your judgment when it comes to collector's items, because 2 years ago, Mischief did exactly the same thing, but instead of Satan, they went with Jesus. So it's the same model. The Nike, I don't want to screw this up, Air Max 97, except the black and red, they went with this white color, and then it did have a water from Jordan River. there was no lawsuit. So pretty much what happened was Monday, March 29th, the complaint gets filed. Along with the complaint, there was a motion for temporary restraining order. 2 days later on, 3 days later on Thursday, the court grants their TRO motion. And then shortly thereafter, the parties settle. I think the settlement was also interesting in that as part of the settlement, the Nike and Mischief agree to have voluntary recall. So I think as of the filing of the complaint and a TRO, 665 pairs were already sold. And then before the ruling happened, the entire 666 units were sold. And then they said, okay, we're doing a recall. And then Nike actually said, come to me, or if you don't want to come to me, but if you have any problem with your shoes, contact Mischief. So that's kind of the bulk of the story there. As part of the opposition to the TRO, Mischief's counsel did make an argument under the First Amendment. So it would have been interesting to see what would have happened. We will never know. But based upon the Honey Roger, the Ninth Circuit language there, where it says, in some incidents, even if you didn't do anything else other than using the trademark, so long as the consumers explicitly associate the trademark with this particular entity, that in and of itself may be sufficient. So under this First Amendment argument, I think the Nike would have been able to satisfy proving infringement. Yeah, this was definitely an interesting analysis. So I want to kind of turn this back to you, Anne and Rebecca, as to what I think the first sale doctrine, it's there, but I don't know if it's strong enough. Had it been raised, would that been strong enough in this context?
Right. And so for the first sale doctrine, it allows purchasers of goods to resell the goods. Like I could resell household items on eBay, Craigslist, that would be fine. But if they've been refurbished or if they're used, you need to make that clear when you're selling them. And this is, I mean, I think this is really interesting because clearly they're refurbishing this. Somebody mentioned in the comments that we were given, there's an entire industry of people who customize sneakers. The Satan shoes could really affect that. What I think is interesting is to think about this absent all the publicity, and say that somebody is maybe selling on, I don't know, Etsy, shoes Satan shoes that they've put together. And in that case, it might be possible that the next purchaser wouldn't know the history of the shoe, or wouldn't have this, because I feel like now there's so much publicity that it's really hard. The whole confusion thing, I don't know. It seems so unlikely to me that people are really confused by this, but if the shoe kind of gets sold down the line, it seems for these that it's less likely somebody would be confused as to the kind of the secondary source. But if they were just shoes you bought on eBay that had some kind of distinguishing marks on them, then you might have a better claim. So
I think the thing is that they also make limited, right? They also make limited customized versions of the shoes. So this takes us back to Jack Daniels, that, Nike is already in that space of having limited run customized sneakers. And I think that's why it's problematic. But yeah, there has to be a reasonableness read into consumer confusion on some of these things. I mean, we have people in this country taking heartworm medicine for dogs to deal with a pandemic. So there has to be a reasonableness read into this somehow, because again, this is a copyright test. How much are you taking of the work? Nominative fair use in the copyright sense, if you're going to write an article about the New Kids on the Block, you have to say New Kids on the Block in the article. I mean, this shoe producer is really taking the trade dress of the shoe. It's not taking a piece of it, it's taking the whole of it. And I think that is kind of dangerous to kind of throw this terminology around. Well, it's just a small taking. No, that's you're taking the whole of it. You're taking the shoe and you're putting human blood.
I love that you said that, because that was one of the arguments that the Mischiefs made. They said, we consider this shoe to be our canvas. So they took the whole thing, and this is their canvas, and they're expressing their artistic content on the shoes. So it is conflating a little bit of the copyright and the trademark here.
Right. And how much expression do you need to put in to be able to be, is this a Rogers test? Is it artistically relevant to put human blood into the shoe? Is it, explicitly misleading? Are these explicitly misleading as to the source? Let me go back to it. I mean, I don't think it meets that whole test. One thing I just want to go back to also is just to look at the elements here. And you would think, looking at these, that it would be a defense, that if you can follow these factors, then you're able to say, well, this is nominative fair use. I should be able to beat any claim of likelihood of confusion. I mean, these, I think, seem to go to, is there likely confusion? And here are the reasons why there wouldn't be.
One thing that I was wondering, though, if Mischief, some articles, they talked about how they did come out and put some kind of disclaimer. Mm-hmm. I'm not sure if they did or if the disclaimer is large enough, but assume for the fact that actually happened. They kind of went out of their way to make it very clear that Nike is not condoning this. Even then, I am not sure whether that would have been enough, given the amount of actual confusion. And then we can argue as to whether those are reasonable or not reasonable. But if there was a summary judgment motion, I am not sure whether it would have been granted because of the fact issues.
So,
on the first sale doctrine, if they had an express disclaimer, it wouldn't be enough. The first sale
doctrine.
So Bree says there we have a lot of questions. So, Bree, do you want to jump in and give us the questions, or? They're in the chat. Okay, fair.
I can put some of these in here.
Right.
So first of all, there were comments about how we need a trademark specific court system. Same with copyrights. That was Matthew Goings who said that. Do you have any feedback on that?
Having a trademark specific court system.
The copyright courts are going to be voluntary, so we'll see if anyone uses them, is what I would say.
I mean,
it
depends on your attitude toward circuit splits. Are the circuits trying to figure things out? Is that a good way to interpret the law, is to see what the different circuits are interpreting the law as? Because if you just have one trademark court, if you think they get it wrong, that's kind of the end of the line.
Absolutely. I think there's also a lot of discussion about sort of the inconsistency between the responses to the Satan shoe and the responses to the Jesus shoe. And sort of, I think some people were wanting some commentary about that.
I think it's hard to deny the motivation when companies like Nike is initiating a lawsuit, especially highly publicized lawsuits. I think when they're faced with that level of boycott, animosity, negative comments, I think from the Nike's point of view, it must have been very hard not to take any action. But Jesus shoes did not trigger that level of hostility. So when you're having discussion with the higher up not just the legal team, but the business folks. It has to tie to the reputation, goodwill associated with the mark. And I think Nike, when you look at their complaint, they spent the whole first three paragraph. It reads like a PR piece. We're not about this. We didn't condone it. We had nothing to do with it. So I could see, it's beautifully written, but I think they had the court in mind as their audience, but their fans and consumers and the market, and of course the opponent. So, and whether you have different political views or religious view or faith view, I think it's hard to say, yeah, I'm going to sue you because you used my shoes and put some Jordan River water in it and sold it for, $500, as opposed to human blood and reference to Satan all around it. So.
And you can also imagine a dog toy in the Jack Daniels case that was a little more flattering to Jack Daniels. I mean, it was kind of it had all these kind of gross references to, to dogs, and like, I don't know, it was not a pleasant product if you're Jack Daniels to, have the words parodied this way. And yeah.
Absolutely. Erica wanted to know, what about cars and aftermarket customization for cars?
I mean, I will say that I think it's interesting, and it depends on what the customization is. I have a client, they make hearses, and they buy the chassis from Cadillac mostly, and they cut them and they make these hearses, and the Cadillac symbol stays on the back of the car. And Cadillac has a very long-term relationship with this particular customization, and so it's a back scratching kind of thing. And so they never challenge that because they make money off of it and they have a history in that particular market. So I think what's interesting, why the Nike thing is interesting, is because Nike also does that kind of limited run shoe thing. And that's why it's more problematic for them. But if you think of it like, using a copyright metaphor, like a fan work, where you have a particular product that is customized, like a specially detailed car, and you could see how consumers would not associate that with the original manufacturer, and that is a separate market. And I think under the case law that we're saying, it's like the first sale doctrine should apply in that case, because they should publicly say, hey, we're taking this product, we are transforming it, using another copyright term, we're making a transformative work here. Don't, draw any association back to the original person. And I think that if the goal of trademark law at its core is still to protect the consumer, that should be enough. And we should want these transformative works to be happening, because that's art. It's commercial speech, but it's art. It's saying something. It's speaking to a certain consumer. So, I mean, I think the car question is an interesting one. And I think you have to look at, as with so many things in trademark law, what is that industry? What is common in that industry? And in the car industry, and in very specific incidences, it's very, very common that it's a third party transforming something, and the original owner gets some kind of benefit from it. I mean, nobody's making like a death car with human blood in it, right? A funeral car is
Maybe
a specific example.
Yeah. Okay. All right. I think that was the majority of the question. We have about 2 minutes left. I know you still have several slides, so please continue.
That
Okay.
was.
All right.
To go back and that was our slide.
Okay. Well, then I'm going to advance it one more, so that everybody has the contact information you wanted to share with them. I want to thank you all tremendously. This was an incredibly engaging conversation, and the chat was on fire the whole time, and not just because of the fire and brimstone from the Satan shoes. So we have marketing sense, ensuring your marketing is ethics compliant, starting at 4:45. So you have about 6 minutes or so to take a quick break. I will see you here in about 6 minutes. Thank you so very much, Anne, Rebecca, and Irene. I really appreciate this. This was a wonderful discussion. Thank you so much.
Thank you.